I call the Honourable David Parker.
Thank you, Mr Speaker. Can I first begin by saying that I think it is a great sadness that this bill doesn't settle the issue. And as I've said and other members on behalf of the Labour Party have said previously, that really does mean that the objective that the that the National Party and the Maori Party set for themselves has not been met. We were very close to being able to achieve a settlement that all sides could live with. If there had been an acknowledgement on the part of the Maori Party that this legislation, when passed, settled the framework for determination of foreshore and seabed in a fair way, then I think the rest of Parliament would have rallied around. We'd have tried to deal with the detail of the threshold test. We'd have tried to take some of the ambiguity out of it. We'd have tried to ensure that it was fair. But of course the Maori Party didn't take that stance. They actually said, we don't accept it's fair. They said that at the co-deputy leaders, the Honourable Tariana Turia, the Honourable Peter Sharples and their Chief Whip Turo Flavel said the same thing. And as a consequence, this Parliament has been left with an assertion that this settles issues when we know both from the attitude of parliamentary parties, including the Maori Party, including the ACT Party, including Hone Hauwera and others, that it is but a fiction because they don't accept that this is a fair settlement. And that's where for me there is a certain sadness, because the issues have narrowed. I do agree with the Honourable Tau Henare that this legislation has never been about access to the beaches, and that people who use that language are being divisive and they are endangering race relations. It's something that the Labour Party did not do during the first foreshore and seabed debate, nor in this foreshore and seabed debate. And I do have to put on record in response to some of the criticisms that Tau Henare just made of us, some of the comments that were made in respect of the last foreshore and seabed bill. Some of the worst of them came from current ministers of the government. Dr. Mapp said what the government is doing here is clearly preferring Maori and above all other members of the community. So it's very clear that we have two classes of citizenship. Maori are in the preferred position. That was wrong. It's absolutely clear if there are two classes of citizenship in New Zealand, those at the bottom of the economic tree more often than not are Maori, not non-Maori. Nick Smith said the bill is racist, the bill is flawed. He said that 10% of the coastline was going to be vested in new foreshore and seabed reserves, and he was replying to what Dover Samuels on behalf of Labour had said about how it would not make any difference to families wanting to go down to the beach and have a barbecue. Dover Samuels was saying that in this House because National Party members as senior as Don Brash, as Bill English and Jerry Brownlee had all been saying that. So Dover Samuels was making the point that wasn't the case with the legislation, and indeed there was an explicit clause in that legislation that preserved public rights of access. What did Nick Smith say in the time? He said, well, yes it does, and I'll tell members why. In relation to the 10% that he'd previously said was going to be under the control of Maori, as that his Maori caucus claims will now be foreshore and seabed reserves, it will be for the management committee to decide who will have a barbecue and where. So that was what Hansard shows was being said at the time, and it was irresponsible, and it caused a real divisive hatred around this piece of legislation, which this country has yet to get over totally, because there are still misunderstandings in respect of both ends of the spectrum of opinion as to what was the effect of the Ngāti Apa decision, what is the effect of the Foreshore and Seabed Act that we passed, and what is the effect of this bill. Mr Speaker, coming back to the issue as to whether there has been political leadership, I've quoted before a column that I thought summed up this, which was by John Armstrong, and I know I've referred to it a couple of times previously, but it is worth repeating because I thought he hit it on the head. He said that at the start of this debate we had the Maori Party and their forerunners saying that the existing legislation, the Foreshore and Seabed Act, was far too rigid and didn't fairly recognise Maori unextinguished customary interests in the foreshore and seabed. That was at one end of the spectrum. We had the National Party at the other end of the spectrum saying, yes, it did far too much. And in the middle we had Labour, who were actually closer to the Maori Party end of the spectrum than they were to the National Party end of the spectrum. The National Party moved past us where we were in that Foreshore and Seabed Act, and they did what we had recommended in our submission to the review tribunal, which was to restore the right to get a remedy from the court. You always had the right to go to court to show that, but for the Foreshore and Seabed Act, you had an unextinguished interest. You didn't have a right to get a remedy from the court, and you had to go back and rely upon a negotiation with the Crown, effectively the grace in favour of a future government, and a future government could do an injustice by refusing a remedy, and that was wrong. We said that was wrong. We actually agreed with the Maori Party on that. That could have been achieved by way of amendment to the legislation. They've chosen a repeal route. We could have gone along with that too. Anyway, we moved there, the National Party moved there. We could have even been pushed a little bit further on some of these things if we actually got certainty. But we couldn't, because the Maori Party wouldn't make that little movement from where they sat to actually being leaders and actually saying this is settled for the sake of our country. So we then put up another remedy and we said, look, if we can't reach agreement as to what the appropriate threshold tests are, let's do what the Greens and the ACT Party have suggested, which is actually put the whole thing back to the court, including the threshold test, and let them determine the threshold test. That way, Maori rights would be fully recognised. There's no longer any misapprehension that access is at risk, at least in this House. That would have been a good solution. It would have also ensured that Maori customary interests were no more than fully recognised. Well, that can't cause an injustice because this is all about the common law right in the first place too. So that's why the Maori Party, and we represent the broad spectrum of opinion within the country. We have a very strong Maori caucus who are keen to protect the legitimate interests of Maori, to protect their unextinguished customary rights, and we have representatives of other parts of society as well. And actually we all agree that our Maori members are right. We should fully, but no more than fully, recognise unextinguished interests in the foreshore and seabed. And so we proposed that the whole thing be referred back to the court. There was general agreement that there needed to be legislation for the sake of settled race relations, really, that access wasn't a threat. There was general agreement that we had to make sure that customary interests could not be alienated because there was a theoretical risk under Te Ture Whenua following the Ngāti Apa decision that recognised customary interests could be converted to freehold title and then sold. So it was always necessary to have some legislation to close off that possibility. And there is now agreement that there was appropriate legislation and was appropriate to legislate re-access. So, Mr. Speaker, we're here not because of a failure on the part of the opposition parties to show willingness to compromise and to get this settled. We're actually here because the Maori Party wasn't willing to make that little bit movement. And we're actually also here because the Prime Minister was not willing to pick up the phone to the Maori Party and say, this is the deal, guys, but we said we were going to settle this, and unless we settle it, we're not going to go through with this charade. And if he had done that, well, we might have a settlement also because the Maori Party might have backed down to that. Or alternatively, the National Party could then have said, well, look, we accept that this can't be settled as to codification of the threshold test isn't going to work. We accept that that's not going to work to the satisfaction of the range of interests that are showing up to Select Committee, and so they could have moved to our position and referred the whole thing to the court, and that would have settled it too. So, Mr. Speaker, it's a sadness that this is not settled. Can I turn to some of the problems that we're left with the process? You know, we still don't know what the legal effect of these changes to the thresholds test is because Parliament has not had any legal... What I do, we've had Simon Bridges. Well, it would have been helpful if you told us at Select Committee. You know, we were blocked from obtaining legal advice. The last Foreshore and Seabed Act had the benefit of advice from a professor who was happened to be visiting New Zealand from Cambridge University, who was an expert in these matters of international common law rights relating to unextinguished customary interests. Mr. Speaker, we had no such advice at Select Committee. The government blocked us getting the advice that they already had. They refused to let that advice come to Select Committee. They're entitled to do that. They can claim privilege, but if they claim privilege, really it does show that the Select Committee should be getting its own legal advice. We're now left with both Maori submitters and some of the submitters like the Coastal Coalition having completely different views as to what the effect is of the test because it remains uncertain. Mr. Speaker, the Labour Party opposes the passage of this legislation.
Members, the next call is a split call, and there'll be a bell at 4 minutes. Paul Quinn.